Um, Good afternoon. My name is Claire Murray, Dr. Claire Murray. I'm a lecturer here in the Faculty of Law in UCC, and in my allocated 10 minutes I'm going to talk about modernising the law of guardianship. And just to clarify, I'm speaking about guardianship of infants, guardianship of children, so the rights and responsibilities that people have in relation to the upbringing of children. It links to Fergus's paper in that he spoke about the Law Reform Commission and the Law Reform Commission recommendations in relation to extending guardianship rights to same-sex couples. I'm also going to be addressing some of the Law Reform Commission recommendations, but looking at it in a different context. There'll be a different focus. And I should declare an interest at this point in that I was the researcher on the Law Reform Commission project on legal aspects of family relationships. So what I want to look at is this, as I said, the guardianship rights. So it's the Guardianship of Infants Act 1964, which is the relevant legislation. And it's obviously very outdated terminology, so even the term guardianship is archaic. And as Colin mentioned, the Law Reform Commission has recommended changing it to parental responsibility, but I'm not going to deal with the terminology issue here. But it's very outdated, and it has a very narrow understanding of the family underpinning the legislation, and that's linked to the very narrow conception of the family in the Constitution, or as I perceive it anyway. So you have the family based on marriage, and the legislation reflects that. So it accords automatic guardianship to married parents and to non-marital mothers, but it doesn't afford automatic guardianship to non-marital fathers. And as Fergus mentioned, the McD and L case, and that accepted that at no time in the immediate future anyway are we going to have constitutional recognition of the de facto family. And so in order to address some of the issues facing families who are maybe outside that narrow understanding of it as is contained in the Constitution, there's a possibility to address that by legislative reform, so that the legal framework begins to reflect the reality of many families, which it doesn't at the moment. So my Dear Minister letter, which Snoopy is busily typing for me, I have two core issues, I suppose. The first being that I would like the Minister to implement the Law Reform Commission recommendations in relation to the guardianship of non-marital fathers. And the second is that the Minister would address the absence of legal rights for members of the extended family raising children. So slightly different to what Fergus was talking about, which is a social parent in the context of a relationship or a de facto family. I'm talking about where you have grandparents, aunts, uncles, siblings raising a child in an informal way, and they don't have the legal rights to allow them to do that in the most effective manner at present. So the current position, I'm assuming that most people are aware of the current position of non-marital fathers in Ireland, but just to give you a whistle-stop tour of it, there's no constitutional right in respect, a non-marital father has no constitutional rights in respect of his child, which was set out in the Nicolau case. And as I said, no constitutional recognition of the de facto family. And a non-marital father can obtain guardianship in three ways. So by marrying the mother of the child under Section 1 of the Legitimacy Act 1931, as amended by the 1997 Children Act, by agreement with the mother. So if they agree and make a statutory declaration to the effect that the non-marital father has guardianship, that's another manner in which he can obtain it, or by application to the court, Section 6A of the 1964 Act. So they're the three ways in which a non-marital father can obtain guardianship rights. So this is a child law event. You may be wondering why I'm talking about what's traditionally or colloquially known as father's rights issues at a child law event. But if you look at it through the lens of a children's rights perspective, this is very much a children's rights issue as well. So Article 7 of the UN Convention on the Rights of the Child should be registered immediately after birth, should have the right to a name, the right to acquire nationality, and as far as possible the right to know and be cared for by his or her parents. That's my emphasis there, but plural, so both parents. And Article 18 again refers to the recognition of the principle that both parents have common responsibilities for the upbringing and development of the child. And again, that's my emphasis. And the use of the term responsibilities there, I suppose, would feed into, as Fergus mentioned, the recommendation that you would change the name from guardianship to parental responsibility, that would reflect the responsibilities that parents have towards their children. But this principle is an aspect of respecting the rights of the child as set out in the Convention on the Rights of the Child, and it requires that recognition of the role of both parents in the life of the child and the right of a child to be brought up by both their parents. And I would contend that at present the Irish law doesn't do this. As we've seen, it operates from a perspective that a non-marital father has to prove that it's in the best interests of the child that he would have a role in the upbringing of the child. And he either has to prove that to the mother, so that she marries him or enters into a statutory declaration affording him guardianship, or he has to prove it to a court. It doesn't start from a presumption that it is the right of the child and in the best interests of the child to have a relationship with both parents. Excuse me. And so the Law Reform Commission recommendations for reform in this respect attempt to address this issue, and the Law Reform Commission did refer to the Convention on the Rights of the Child as an underpinning or a benchmark to all their recommendations in that project, and also as the kind of informing the mindset of the Commission as they approached this issue. So the recommendation was that, and it was a report from 2010, it would require the names of both parents to be entered on the birth certificate of a child, subject to limited exceptions, and then the guardianship rights would flow from the entry of the name on the birth certificate. So you would be assuming that in most cases two names would appear on the birth cert of a child, that they're the name of the mother and the father, and once the names are on the birth cert, that the person would have guardianship rights in respect of the child. Now, there is subject to limited exceptions, so it is accepting that if the mother doesn't know the identity of the father, doesn't know the whereabouts of the father, or states that there's a risk to the welfare of the mother and or the child, well, there would be an exception in those circumstances. But that's, providing a statutory exception for what are exceptional circumstances, and starting from the position that it's in the best interest of most children, and it's the right of most children to know and to be familiar with both their parents. So that's the first issue. I'm not going to go into the very detailed recommendations that were set out in that respect, but I can talk to you about them later if anyone is interested in the detailed provisions. Just to note that the Law Reform Commission did recommend automatic guardianship rights for non-marital fathers back in 1982 as well, and that hasn't come to pass. So the fact that this is a 2010 report and we're just into 2012, I don't think we should be complacent or think that it's not an issue that needs to be addressed and doesn't need to be pushed, because I think it is a very significant issue. The other issue I wanted to address then was the legal rights for members of the extended family caring for children. So not all children are being raised by their biological parents. I assume if there are a lot of practitioners here who are working in the child law area or in the family law area, that's a very familiar circumstance. Where a family member is caring for a child on an informal basis, they're doing so without the legal rights which allow them to do that in the most effective manner. And again, from a children's rights perspective, we're talking about what's in the best interests of the child. And it's in the best interests of the child that the person caring for them can do that in the most effective manner possible. So the relative won't have, if they don't have guardianship rights, the legal authority to consent to medical treatment on behalf of the child, to apply for a passport for the child, to sign consent forms for the child going on a school trip, for example, if they're not a parent or a guardian. Now, in practice, people may find a way around that, but from a legal perspective, they don't have those legal rights. And so again, the Law Reform Commission addressed this issue, and they proposed that legislation would extend the right to apply for I'm bang on time, good stuff. Extend the right to apply for custody to persons other than parents or guardians. So at present, as Fergus mentioned, relatives or persons in loco parentis can apply for access to a child. The Law Reform Commission was suggesting that these categories of persons would also be entitled to apply for custody of the child. They also wish to extend that to include bona fide persons with an interest in the child, which is and that was taken from Section 37 of the Child Care Act 1991, which allows for a broader category of persons to apply for access to a child in care. So that these groups of persons would be able to apply for custody of a child, and that if custody was granted to that person, the person would be entitled to exercise certain aspects of guardianship for the duration of that custody order, so that they would be entitled to consent to medical treatment for the child or to apply for a passport for the child during the duration of the custody order. It would not have an impact on the guardianship rights of the parents, so it wouldn't remove guardianship from the parents, but what it would do would allow them to exercise the rights that they need to. It would not allow them to consent to the adoption of a child or to appoint a testamentary guardian for a child, because that could have ultimately the effect of severing the guardianship rights of the parent. So it's a limited right. It extends aspects of guardianship to the person for the duration of the custody order, but what it does do is allow them to exercise the rights and responsibilities that they need to care for the child in the most appropriate manner, which is in the best interests of the child. And my time is now up, so I'm going to stop. Thank you very much.